Listen, we got big problems in New Jersey. Did you know that?
We did know that.
Well, let me tell you one of the ones you haven't thought about, I bet, in a long time. There are an enormous number of young attorneys, newly minted, just got done being sworn in. They go into their office for the first day, and their boss says, well, welcome to the firm. Here's this file. Plop. Brand new case. We've just filed suit. Get it ready for trial. Okay? And you're a brand new attorney, just your first day on the job. Besides changing professions, what would be your advice generally to an attorney like that?
Well, my first thing that I would tell an attorney in that situation is to grab an old file in the office that's either been recently completed or is at the stage of getting ready for trial, and have them literally read the file cover to cover. That's the best way to see how the firm they're at or the attorneys they're working for handle a case and what the steps in the process are.
What is the first thing that you think that someone should do? The suit's already been filed, for better or for worse, whether there's a good cause of action or not, whether there's damages or not, whether there's liability or not. Whatever's going on, it's already locked in. What's the first thing you think you should do?
Well, the first thing that I think you should do, depending on what type of case it is you have to look at the rule book.
All right.
You look at the court rules. Section 4 deals with civil litigation, and that's going to give you all of the different steps and the time frames to do the different things that have to be done to get the case ready by way of discovery.
Could you talk about the different types of cases that come out, just as according to the rules, like say the difference between a suit on a contract versus something that's maybe a personal injury case involving an automobile accident?
Sure. Well, there's different things that happen in terms of, in some cases, there's form interrogatories, meaning that the Supreme Court has said in these certain types of cases, attached to the rules are the interrogatories that have to be answered by the parties within certain time frames.
So
for instance,
the interrogatory is right in the rules itself?
Correct. It's an appendix 2, I think, to the rules. But for instance, any personal injury case, there are form interrogatories that a plaintiff must answer, form interrogatories a defendant must answer, and then certain subsection interrogatories based on whether it's an automobile accident, a slip and fall, a medical malpractice, product liability, or what type of case it is. In a book account, I don't believe there are form interrogatories, meaning that you can create and send your own interrogatories out. But it's all set forth right in Rule 417.
All right, so the first step then is to go to Rule 417 and then go to the appendix, get out the appropriate interrogatories. Now, can you propound additional questions along with those interrogatories?
You can. When it's supplemental interrogatories, if it's form interrogatories, you're permitted to send 10 supplemental interrogatories without leave of court. After that, you'd have to file a motion to serve more than 10 additional supplemental interrogatories. And what I would tell somebody is if it's a book account or a commercial matter and there are no form interrogatories and they've never done this before, start with the form interrogatories as a guideline and then modify or work from them, and you'll be able to create most of what you need.
Now, physically, how do you go about serving these on the person who has to answer the interrogatories?
There's two different ways. If it's form interrogatories, they're deemed served with the filing of the complaint or service of the summons and complaint, or with the answer. So there's a time frame. For a plaintiff, it's 30 days from the date that the defendant answers. For a defendant, it's 60 days from the date that they've answered.
All right, can you kind of flesh this out a little bit, though? What do you mean by that, that they're deemed to be served?
In other words, if you're a plaintiff in an automobile accident case, you file your lawsuit.
I filed my suit against the other driver.
Right, you file the suit against the other driver, and then when it comes back from the court with a docket number, you prepare a summons. You send the summons and complaint to the sheriff or to a private process server.
Right.
Once it's served, defendant has 35 days to answer the complaint. When they answer the complaint, the day that they file their answer with the court and send you a copy of it, that triggers timeframes. It starts the whole discovery process. So the first thing that happens is you now are deemed as a plaintiff. Once you receive that answer, you have 30 days to provide answers to interrogatories.
It doesn't matter that the interrogatories were never physically sent. They can just get them out of the court rules, right?
Correct. You're deemed to have been served with those Form A or Form A interrogatories.
Because everybody's working from the same script, so to speak.
Exactly.
Now, if you had supplemental interrogatories, those should be served, though, wouldn't you? I would think.
Yeah, supplemental interrogatories need to be served, which just means that they need to be sent from attorney to attorney.
Okay. Assuming that somebody's entered his appearance. If there
Right.
is no attorney on the other side, we just send it right to the defendant?
Well, there's nothing to send. If the defendant,
No, I meant for supplemental interrogatories.
right, but I wouldn't serve them until the defendant has answered. So if the defendant answers pro se,
Right.
then yes, and I would always send, if it's a pro se party, certified mail.
Okay. So you sent your interrogatories over, either the ones that are in the court rules or with 10 supplemental questions, or even more if you have leave of the court. And how long do these individuals have to answer these interrogatories?
They have, on the Form 1s, it's time frame of 30 days from the date the defendant answers for the
Right.
plaintiff, and 60 days from the defendant's answer for the defendant. Otherwise, if it's a case that doesn't have form interrogatories, it's 60 days from the date that they're served that a party has to answer interrogatories.
Okay. And when you go through these interrogatories, do you review them with your clients, or do you just say, here's a piece of paper? Or do you have Christy do it?
Well, I'll let Christy talk about what we do with our office.
Now, let me hear it. What do you do in your own office? Do you sit with your clients and answer them, or is that too boring?
No, we actually do, because these are answers that are coming from our client. These are
Right.
going to be used throughout discovery. They might be used at trial. And if we're just answering them, we weren't there when whatever the incidents happened, whether it be a personal injury matter or whether it be a breach of contract issue. So what we do is we call them in and we sit down with them and we go through each question. I'll handwrite the answers while I'm going through with them, and then I'll have my assistant type it up afterwards, so that way it looks a lot nicer and neater so we can send them out. In rare instances, we have a client that maybe they live out of state and they can't come in. What we'll do is we'll mail it to them and we'll go over it over the phone with them, and we'll be able to make sure that they're understanding the question, and that way that they're answering it
But you are
appropriately.
supervising pretty much every one of their answers to get it to the point where it accurately reflects the information that's sought in the question.
Absolutely, absolutely. We're not just letting them have free range and writing whatever they want, because sometimes they write a lot more than the question's actually asking for.
So they're volunteering stuff that may not necessarily be helpful or
Correct.
relevant, or might be more harmful than anything else.
Correct.
Would you ever take a situation where you would just hand a bunch of interrogatories to a client and say, just go write up answers to this and bring it back to me when you're done? Would you ever do that?
There's been a rare instance when I've done that, and what will happen is maybe a client works 2 jobs and they just can't get that phone conference with you. So I will look at them when they come back in, but sometimes they don't always answer the question. They might answer something different than what the question actually asks. So then in that case, we need to call them and clarify that answer before we can have anything finalized.
Now, what goes through your mind when you're answering these questions? I mean, are you thinking about trial down the line and the impact that a particular answer is going to have at trial, or legal issues that are going to come up in that context? Or is it too early to start thinking about that?
No, you're thinking about all of that, because everything you do throughout discovery is going to impact the trial. So if the client, for instance, say one of the questions says, what time of day did the auto accident happen? And say the client has no idea, and I don't know, say for some reason there was no police report that was actually filed.
Right.
If the client just makes up an answer, he's going to have to make that same answer up later on, which looks very bad. We don't want someone to make up an answer. We want someone to answer only what they know, because it's going to impact them later when people are pointing it out.
Well, let me change the question a little bit. I guess what I'm trying to ask you is this. When you you're reviewing an answer that your client has given, in the back of your mind, are you thinking to yourself, how's this going to play out if there's a summary judgment motion? How's this going to play out on the cause of action? How's this going to play out on damages? How's this going to play out on credibility? How's it going to play out at trial?
Yes.
Are these questions that go through your mind?
These are questions that go through your mind through every stage of the process.
But in particular with respect to the interrogatories, because it seems to me you have more control over the interrogatories than you would say at a deposition.
Absolutely.
Where your client's, kind of talking free rein, so to speak. So do you agree with that?
Yes,
Do you think that's good advice for people to keep in the back of their minds when they're answering these things?
absolutely.
Okay.